Good morning, everyone. My name is Kathy Purdy, and I would like to welcome you to today's presentation, Survival Strategies for Addressing the Challenges Posed by Medicaid Managed Long-Term Care. Your presenters today are Mark Mainello and Raul Flora from Bond, as well as Jerry Archibald with the Bonadillo Group. For those attending via webinar, please enter your questions in the chat or question box located in the GoToWebinar control panel, and your questions will be addressed as time allows. If you requested NAB credits, your certificates will be mailed to you within the next 2 weeks. Anyone requiring CPE credit, please stop at the registration desk at the conclusion of today's presentation for your certificate. I would now like to introduce to you today's presenters. Raul Tabora has spent his entire career in healthcare law. He represents health and long-term care providers, bringing years of first-hand experience in the area of compliance to develop internal procedures to avoid fraud and ensure proper reimbursement. Raul has decades of experience representing clients in both claims against governmental agencies as well as defending against audits, investigations, and overpayment recoveries. Mark Mainello is a long-term care attorney with 15 years experience representing nursing homes in construction and commercial contract reviews, transactional support, guardianship matters, administrative fair hearings, civil litigation, and appeals. Mark has an additional 9 years of experience in real estate, trust and estate practice litigation, and surrogate court representation. Jerry Archibald is the partner in charge of the Healthcare Tax-Exempt Central Division of the Bonadillo Group. Jerry has over 35 years of experience in providing business, advisory assurance, compliance, and consulting services to healthcare, tax-exempt, and government clients. His expertise in the health and human services industries has provided him with a unique perspective of all aspects of health and human service delivery systems. It's now my pleasure to present to you Raul Tabora.
Okay, thank you very much.
You're welcome.
And I'd like to thank everybody for coming here at 8:30 in the morning and listening to some very turgid material on MLTCP, FIDA, and a variety of other new monsters that the state is creating for the various industries. We're going to focus on, and I know that there have been many presentations over the last 2 years, as the state is churning away and developing a managed care program for all. Managed care for all is the agenda, and that is a very true statement on the part of the state today. We're going to focus on some nuts and bolts aspects after some history and overview. Network integration development, admissions and discharge criteria, loss prevention, receivables management, managed care contracting, and some IPA issues. There are monumental changes that the state and the federal government want to implement. And I've heard that now since 1992 when they first started the managed care agenda. But they have been slowly implementing this program, starting with children's services back in 1992 and going on through community-based care and now institutional care. In the nursing home context, while these monumental changes are happening, the care conditions of the individuals that we serve haven't changed. I mean, they're getting worse. People are living longer. Chronic care conditions are, because of that fact, need to be attended to even more precisely than in the past. So in terms of the provider side, the way I look at it is we need to assure that we're fitting in these monumental changes with the existing care needs of our residents. The Managed Care for All program also involves, and this will be a secondary aspect to the state's agenda, OPWDD facilities, OASAS facilities, substance abuse. There are a variety of programs called DISCO and HARP that are in the works and will take over in pretty much the same fashion with some changes based on the care needs of that population. And the expectations are that we want to get rid of the silos. So silos of a hospital, a nursing home, home care provider, OPWDD provider, all of the various waivered programs. We want a mega system, an integrated delivery system. That's where we're going to save some money through overhead savings and through integrated delivery. The reason for this, and I think it's very important to understand the financial pressure on institutional providers. In the past, there has been a robbing from Peter to pay Paul methodology. So Medicaid is traditionally paid at a sub-cost rate, at least in the nursing home side and in the hospital side. And that has been supplemented by private pay revenue along with Medicare. Each one of these categories, however, now is being ratcheted down. And you're seeing a perfect storm where that what is known as cross-subsidization, meaning that Medicare and the private pay folks are going to subsidize Medicaid, is just not working because the private pay population now is paying double their mortgage in insurance premiums, first off. And Medicare has been, over the last 8 years, severely ratcheting down their reimbursement. So in order to address that, you see the managed care program. And they're still working on it. So they being the state and the federal government in terms of coming up with a program that works. That's why you'll see that a lot of these things have been delayed since last year in terms of implementation into the institutional setting. I think it's important to know the policy behind these changes. Once you figure out what the policy is, then you know what direction the state is heading and what you need to do in terms of survival during this process. In 2005 data, CMS compiled a listing showing that potentially $10 billion could be saved by avoiding hospitalizations. So their focus was, and this is nationwide, their focus was, well, how can we prevent the frequent flyers, as they call them, people coming in and out of the hospitals from nursing homes and also from the community. And you'll see that this is a major, major part of all of the reforms, whether they're called DSRIP, we'll talk about DSRIP, whether they're called accountable care organizations, whether they're called MLTCP or FIDA, the focus is on the reductions in hospitalizations, keeping people well in their homes. That's basically the program. Why? Well, this is the bending of the cost curve that has been much touted by the governor over the last 2 years. And you'll see that from 2010 to 2012, they actually did decrease, and were successful in ratcheting down the level of expenditures, Medicaid expenditures, in the state of New York. And that's a total cost curve. So there's money, and then there's care in the least costly, most qualitatively sound setting, ideally. And this is the answer. I've tried to capture exactly what managed care will mean for a variety of populations. MLTCP, the Managed Long-Term Care Program, will be mandatory for Medicaid in the institutional setting. For nursing homes, and this is the nursing home transition part of it, the onset has been delayed to October 1, 2014. And the reason for that is that there's not been CMS approval thus far. They're working out the clinks in the process. And that's going to basically grandfather all individuals that are already on Medicaid. So those individuals will continue to be under what they call the fee-for-service program, where the state pays nursing homes directly, whereas all new entrants will be shuttled over into an MLTCP plan. Within that, there is the dual eligibles, and a lot of focus has been paid to the duals. They account for a very large percentage of expenditures. FIDA, the Fully Integrated Duals Advantage program, is the managed care program on steroids for that population. And that is intended to manage both the Medicare needs and payments for those individuals and utilization, as well as Medicaid expenditures, which are mostly custodial care in terms of the nursing home context. So if you see that large circle, which doesn't include FIDA, that's basically a custodial care payment, which will be managed by assuring that individuals can be either retained in the community setting or discharged to supportive housing, for example. At least that's the ideal. We still have Medicare Advantage, which is the HMO product of choice on the Medicare Part A side, and we have the private pay population. So we have October 1st, 2014 for New York City. They haven't come out with a date yet for the state. I'm speculating it's going to be April 1st. It's likely that those dates may be pushed off, but you never know, because the state's posture is, let's start it. All right, we're tired of waiting. We've been waiting since 1992. FIDA will start on January 1st. It's projected to start on January 1st. And there's a concept of passive enrollment, which will be very, very critical, especially given the fact that the population that institutional providers serve are the elderly, people in most need, frail, fragile, may not be with it in terms of knowing what to do when they get an enrollment letter. So passive enrollment means that if you don't object, if you don't opt out, you're going to be enrolled in one of the plans that we're going to put you in. Now this structure is on top of a very dysfunctional system. And we have the hospital market going one way, we have the physicians market, we have all these competing interests, and then we have the institutional care providers, home care, supportive housing kind of in the middle. And the intent is to let's get this organized. And the way, the destination point is basically an integrated delivery system. So currently on the hospital side, they are facing a readmission penalty. In October of 2012, CMS on the Medicare side started penalizing hospitals for certain readmissions within a 30-day period, up to 1%. That's going to go up to 3% next year. So in 2015, that's going to be a 3% penalty. Hospitals are very, very interested in ratcheting down those readmissions, primarily from nursing homes. On the nursing home side, they're just beginning to develop health records in many cases. There's a reliance, for the most part, on the standing of the nursing home in the community in terms of market share. And oftentimes there's no formal affiliation with the major hospitals, major entities in their markets. So the destination point is let's have a continuity of care where everybody is cooperating and we're dealing with the needs of the patients without spending too much money. It's a big task, and it's going to take a long time. So as we get into the nitty-gritty of how we're going to do this, I've got a concept here called Interact that CMS has been developing now for probably 4 or 5 years. It's out of their Transitions in Care program. And Interact is, okay, let's get the nursing home and the hospital to talk to each other on a very specific basis with regard to patient care. And that's fine when you have a system where a hospital and the nursing home are part of the same system. The employees are beholden to the same employer, the system. but in most cases that's not the case. So it's important to understand the communication aspect as we go through this is critical. Knowing the policy allows you to better prepare. And as I indicated, ACOs, MLTCPs, and DSRIPs are basically all following the same policy agenda. And the future will depend on the level of collaboration. The future, your survival will depend on the level of collaboration that you have with all of the partners that the various state agencies and federal agencies expect you to work with. I've broken this down in terms of, okay, what do we do to prepare? Network linkage development, coordination of your admissions discharge policies, legal documentation dealing with the individual residents' patients, and then payment and receivables management. With regard to network and linkage development, we have written materials that we've provided because there's no way we can cover this in a 1 hour period of time in great depth, so we've provided some extensive written materials. There are, most organizations will have a basic transfer agreement, will have may have hospital affiliation agreements, and the first step in terms of preparedness is to take a look at those agreements and try to transform them into clinical affiliation agreements. What are you doing with regard to your partners on the institutional side, with regard to hospitals, with regard to dialysis, with regard to arranging and assuring that the needs of your residents and patients are being taken care of by ancillary providers? Now, in this room, I'm not sure how many individuals are part of joint committees. Is anyone a part of a joint committee with hospitals, nursing homes, home care providers? Okay. So you have, the new world of integrated care, in order to work, will require that people talk to each other. So unless you're part of an overall system, where you still have to have that communication, but it's organized by people who can say, you shall go to those meetings. If you are all partners in care, then you're going to have to rely on a legal document, your transfer agreement, your affiliation agreement, your collaborative services agreement. What we've developed is something called a collaborative services agreement, which then allows for a committee on payment issues, a committee on quality assurance issues, and a committee on clinical interaction. So in terms of network and linkage development, assess, who your referral sources are. Assess who you interact with in the community, and then try to formalize that and get involved in quarterly meetings. Medical staff policies. As we later on will get into the FIDA plan requirements and the MLTCP requirements, many of which follow the managed care protocol, where managed care providers want everybody to be credentialed. Well, credentialed with regard to outside credentialing. All right. So everyone is already licensed and credentialed, so to speak, with regard to internal procedures, but external credentialing and review is a big item in this area. So medical staff policies will have to be reviewed. Network credentialing. And even beyond credentialing, just assuring that everyone in your network is part of the same plan. So if you're dealing with an outside physician, or if you're dealing with a particular hospital that may not have a contract with the FIDA plan that you have a contract with, well, that's going to be a big problem. The second area is coordination with regard to admissions and discharge policies. We've provided, as part of the documentation, a document on attachment C, which is called Medicaid, Medicare, Important New Obligations 2010. So in the nursing home context, the regulations require that we advise applicants and residents coming in for admission of their Medicaid and Medicare rights. So therefore, a nursing home needs to know that so that they can properly inform the residents of developing issues. So this, because of the changes, every year we have a new change. Every 6 months we may have a new change. Individuals need to be on top of these changes so that they can explain it to residents, and you have to document it. So we use this document, which is that Exhibit C, to meet that requirement. And just going through some of the other material, Exhibit D is something called an HMO addendum. We need to know in this new world who's going to be paying for the care. Now that's kind of a loaded question because the state and the feds have not decided when they're going to implement this. Even the managed care companies are in the dark in many respects. So we need to try to start understanding what's going on and build these protections into the legal documents that we provide to our residents and to patients. So as we do all of this, the regulations haven't changed with regard to survey requirements. Nursing homes can still be held in immediate jeopardy if care is not provided. So we have to be cognizant of the fact that while we're doing all of this, we need to be acting perfectly with regard to licensure requirements. As we get into the policy implementation, and we look at some of the concrete issues as they're developing on the federal side, we know that in the new world of managed care, we have to, especially in FIDA, we're going to be administering 2 separate programs at the same time. And that will be a challenge. It's a challenge for the federal government to even come up with the requirements. So, for example, there is something called the integrated denial notice. A single notice is expected to be used just to make life simpler for everyone for denial of care purposes on the Medicare side and on the Medicaid side. So at this point, we are kind of wondering how is this going to be implemented. We are looking at other states. How are other states doing? Other states are not doing very well in terms of the implementation. There is duals unfamiliar with managed care. I mean, if the managed care company is not familiar with this program, how can you expect the beneficiaries to be familiar with this program? Just putting that out there because, again, this is part of many presentations that you're probably going to see, and the rules have not been totally written yet. When you look at the FIDA program requirements, and these again are all draft, they have not been finalized, we are peeling back the onion a little bit to see exactly what will happen once FIDA is implemented. And what I've got here on the screen is from what's called a tripartite agreement, which has been approved by CMS, has been signed by New York, and is still being reviewed in terms of its implementation. I think a big factor here is out-of-network participation. There is a built-in safety valve to allow for reimbursement for out-of-network providers in the FIDA program. And there will be a 90-day transitional period for out-of-network providers to enter into a contract with the FIDA plan. as noted here, if the provider does not become a participating provider, or if the participant does not select a new participating provider by the end of the 90-day period, the FIDA plan will choose a participating provider for the participant. So again, in the institutional context, those chinks in the armor are still being worked out. Another aspect of implementation is prompt payment. And here it's important to understand that the managed care providers will have an obligation to pay within a 45-day time period and notify providers of specific reasons why a claim is not being paid within a 30-day time frame. That will also apply to any IPA that's administering benefits for the managed care entity. Another large issue will be appeals and grievance procedures within this context. There are regulations which require appeals, require an appeals process, which is still being worked out by the state and the feds. The concept now is that individuals will have an appeal right when it concerns coverage by requesting a hearing within a 60-day period. The important factor here when you're dealing with institutional care is that there's a concept of aid continuing. So if an individual requests a hearing within 10 days, then the managed care plan must continue to provide a benefit and pay for benefits until their appeal is decided. And I think this is one of the most important regulations out there that will protect both beneficiaries, both recipients, and providers. And that is appealing within that 10-day period. Now, Mark will talk about how do you do that. You know, first of all, you only have 10 days. Individuals may be incapacitated. So as Mark will comment on, it's very important to know who the legal representative may be of an individual in the nursing home context. In the nursing home context, you also have discharge requirements, discharge notice requirements. So it's critical, again, to go into your procedures, make sure that the timing is coordinated. If the managed care plan is telling you that the individual needs to go back into the community, they no longer need to be in the institutional setting, fine, you can appeal that within 10 days, but you also, as a nursing home, have to issue a discharge notice. And if the individual appeals within 15 days, then the individual gets to stay in the nursing home until their appeal is decided. It's a separate, totally separate appeals process. We're not sure whether that's going to be integrated into this, into the fair hearings process or not. It's a good idea to do that, but that is another very important aspect of drilling down and preparing. With that, I'm going to hand it over to Mark to talk about receivables management.
Thank you, Raul, and good morning, everyone. My name is Mark Manello, and I'm a member of the Schoeneck King Healthcare and Long-Term Care Practice Group. As Kathy Purdy earlier mentioned, my areas of concentration include reviewing agreements with respect to providers that include transfer agreements and affiliation agreements. We also do a fair amount of review of admission agreements and take on issues with respect to admission and discharge. And part of that admission packet would include, for example, in addition to the admission agreement, from a receivable management perspective, other agreements known as private pay and NAMI agreements. We also do a fair amount of litigation here in our office that includes Article 78 proceedings, where we're looking to challenge determinations made by various governmental agencies, whether that might be the local Department of Social Services on a Medicaid determination or the Department of Health on a fair hearing issue. We also do a fair amount of collection type of work and receivable management. And we also deal quite a bit with what we're going to talk a little bit more in a minute, is on guardianship work. And that includes Article 81 of the Mental Hygiene Law guardianships and guardianships under Article 17A of the Surrogates Court and Procedure Act. One of the distinctions between those two types of guardianships are important to recognize. Under Article 17A of the Circuits Court Procedure Act, also known as the SCPA, those are typically guardianship cases where the individual suffers from a developmental disability or a mental retardation. Whereas Article 81, it can include those as well as other types of guardianships where you have maybe a resident who is suffering from dementia and is unable to protect themselves. In this particular aspect of our morning session, receivable management, I like to refer to this as a very much abbreviated version of another presentation that we typically like to call When Things Go Wrong. And what we're trying to do here is be proactive to minimize those things from going wrong to the extent that we're able to do that. Traditional problems in this area that we've experienced oftentimes include, for example, having residents apply for Medicaid on a timely basis, and oftentimes they may not do that. For example, their assets may run out several months beforehand. So we have to be very proactive to make sure we're dealing with the resident or the resident's family or their legal representatives to make sure that they are timely applying for Medicaid before they actually run out of assets. When you apply for Medicaid, you are able to go back as much as 3 months for a retroactive pickup, but that's it. Other areas that we concentrate on are recovering private pay bills that remain unpaid, especially if the Medicaid is not timely paid. So, for example, at some point there may be a Medicaid pickup, and it could be a situation where at that point in time the bill to the nursing home might be several $1,000s. So we try to work with the family and with the facility to try to get that recovered in some fashion, whether it's zeroing out the NAMI. We can talk about that in a minute. Other issues that we also get involved with are recovering assets when there may be transfers involved, and that's typically the situation when Medicaid will not be covered because within the 5-year look back there may have been a transfer of a resource, a house, cash, what have you. We also look at issues involving the recovery of income to be applied towards the cost of care. And also in particular with respect to the NAMI contribution. When an individual becomes eligible for Medicaid, they have an obligation to contribute their income towards the cost of care, and we have to make sure we're working with that resident and or their family to make sure that income is coming to the nursing home or to the facility to pay for that cost of care. The big issues, though, are dealing with residents who may lack capacity. And in that avenue, we have to make sure that we know who we're dealing with and who the legal representative of those individuals are. And oftentimes we're talking about powers of attorney, if there are any, legal guardians, if there are any, healthcare agents, proxies, and in particular those situations where those individuals may not be too cooperative. What do we do when we're dealing with an uncooperative power of attorney or a guardian? And again, there are avenues to take with respect to that. But now what we have to do is add on top of these types of issues the fact that we have managed long-term care now. So what other issues on top of this overlay of traditional problems that we have to face with? Well, now that we're dealing with another potential payer source, a plan, MLTCP, we have to deal with issues that they may have, actions and decisions that they may make, which may be implicate or have an impact on the resident and have an impact on the payer source. Coverage determinations and denials are another example. Disenrollment from the plan. An example of disenrollment may be if the resident is not paying their NAMI contribution. That may trigger disenrollment. And what happens then, if they're disenrolled, there's no more payer source. So again, these are things that we have to be proactive on in making sure that we're dealing with these things. And perhaps there may be a situation where the plan itself is directing the facility to discharge the enrollee. As Raul mentioned earlier, another aspect that we have to be concentrating on in this particular area is the timely filing of grievances and appeals and requests for fair hearings. As Raul mentioned, there is the concept of a continuing. Again, the idea is when you are making a first level of appeal on an action or decision made by the plan, that you make sure that the request is made within 10 days so that you get a continuing. If you don't make the request within 10 days, you can still make the appeal, but you would lose the opportunity for a continuing. And then, if that determination is ultimately made by the plan, which is adverse to the enrollee, there's another stage of appeal, which is the fair hearing process. And again, that fair hearing process is not with the plan. It's against the plan, but it's before a fair hearing administrative law judge. But again, that fair hearing application request has to be made on a timely basis. And again, within 10 days, you need to make that request for a continuing to continue that payer source. When you're dealing with an incompetent or incapacitated resident, the question becomes, who are you dealing with to make these applications and appeals? And that's why we have to focus in on making sure we understand who we're dealing with as a legal representative at the onset of when this resident comes into the facility, whether it's a power of attorney or it's a legal guardian. One of the things I wanted to mention is that the regulations regarding appeals in particular state that a provider acting on behalf of the enrollee and with the enrollee's written consent may file an appeal. So in that instance, we may want to consider, for example, at the time of admission to have an authorization prepared at that point in time, whereby the enrollee or the enrollee's power of attorney perhaps can designate the provider to make that appeal so that at some point down the road, we're not scrambling. Now, as I mentioned, in reviewing these issues, we have to make sure we focus on who we're dealing with as a legal representative and what their right and authority is. For example, a power of attorney mostly is for financial decision making. But again, we have to make sure that power of attorney is duly and validly completed and that we're making sure that we understand what that power of attorney's duties and functions are. We also may have healthcare agents. That's primarily healthcare decision making. So there'd be no financial decision-making on that person's part unless they also happen to be the power of attorney. And then we have legal guardians. And legal guardians are individuals who are appointed by the court. And under Article 81, we have what are known as guardians of the person and guardians of the property. But the important thing to recognize with guardians are once they are appointed, we have to look at the order, because the order by the judge is what dictates what their powers are. It's not everything. It's not in for a dime, in for a dollar. It's selected powers. So again, we have to be cognizant of what those powers are. And then we also may have surrogates under the Family Health Care Decisions Act. We also may have in our admissions documents designated representatives. But again, their authority is limited as well. And we have to make sure we understand who they are and whether they have other hats. For example, are they also the guardian? Are they also a power of attorney? And then we may also have individuals who don't have any of these hats, but they may happen to be the person who happens to be the sibling or child who happens to have their name on the individual's bank account. So that may be an individual we may want to have dealings with for perhaps preparing for Medicaid. One of the things I want to mention very briefly, though, is with respect to powers of attorney, oftentimes what we'll see is in the admission packet, we'll see that the agreement between a resident and the facility is a three-party agreement. You've got the nursing home, you've got the resident, and oftentimes we'll have another signature line for the resident's designated representative or a responsible party. When we're dealing with the power of attorney, one of the things that we want to focus on is to make sure that when that admission agreement is signed, if the resident is able to sign the admission agreement, they have capacity, they should be signing that agreement on the resident line. And we should also be having the power of attorney sign on the designated representative or responsible party line. Therefore, we then have that individual also undertaking certain independent responsibilities under the admission agreement. Whether that may be, for example, making sure the resident's bills are being paid from the resident's funds, from their income, from their resources. And in particular, with respect to Medicaid, making sure the NAMI contribution is paid over.
There's one of the, I think you were going to get into this, Mark, but in the past we've had an appointment of representation form, an appointment of representative form that's been required by Medicare. So when Medicare issues a notice of Medicare denial, for example, they will accept their own particular form, which is signed by the resident or the POA, to allow a representative to appeal on their behalf. So we have this 10-day time limit with regard to aid continuing, which is going to be a critical factor here. Can you comment on admissions policies or intake policies to focus in on that type of particular form?
Yeah, and that's a great point, Raul. We want to make sure that on the front end, during our admissions agreement package, we do have these authorizations and agreements in place which designate the legal person who's able to make decisions for a resident, especially if they're not capacitated, to be able to make those types of decisions and be able to fill out those forms and to make those determinations so that we're not doing it after the fact or on the 9th or 10th day when it's possibly too late to make that particular request or appeal.
Right. Also, with regard to passive enrollment, if there's any, there needs to be someone to decide for the resident, if the resident can't do so, to enroll in a particular plan or to opt out of FIDA.
That's correct. That's correct. And many times we are dealing with residents who do lack capacity, and in that respect, sometimes we may have to resort to the guardianship process. We don't do so quickly. We try to do alternatives, make alternative steps to try to solve the problem, and sometimes a guardianship is necessary. And what we have to recognize is, with respect to guardianship, unlike a power of attorney, once a guardian is appointed, they have a duty and obligation to act on behalf of the individual, on behalf of the resident. They have to act in their best interests. A power of attorney has to act in the individual's best interests as well, but they can decide on a given day they don't want to do anything for that resident on a particular day, whereas a guardian has no choice. And so the guardianship is a very important role and function. They also have obligations to report annually. Those reports are sometimes accessible. If they're guardianship of the property, we can monitor what the individual's assets are. If it's guardianship of the person, we can also see to make sure this individual is being cared for, and that there's an obligation that they also have to visit the individual at least 4 times a year. Again, the idea, though, is to make sure that we have this guardianship in place, or this power of attorney in place, because now we have to have decisions being made for MLTCP plan purposes. In the past, when we had a guardian appointed, oftentimes the issue would be we're looking to have someone apply for Medicaid, gather all the documentation to do that. It's a 5-year look back, there's bank statements, there's a lot of gathering of work. And if you don't have a particular person with access to the individual's financial documents, oftentimes we're looking at a guardianship to do that much. Once the individual ultimately is approved and put on Medicaid, the guardianship's role oftentimes becomes minimal. And we've also encountered situations where the guardian, once appointed by the court, may seek to become discharged. And that may not be a problem, because after the guardianship, after the guardian has put the individual on Medicaid, there may be an annual recertification process that the facility itself can actually handle. So there may not need to be that guardianship. Well, in this area of managed long-term care and FIDA, that may no longer be the case, because under the NLTCP, there's going to be decisions that have to be made, whether it's enrollment issues, actions made by the plan itself that may have to be challenged. So we may not want to see that guardian become discharged. And we want to make sure that guardian is still in place for those types of decisions, especially with respect to the hearings and appeals process. It's important for us as the facility to have a point person to deal with, especially a resident who's unable to make decisions for themselves. One of the other things that we've been also able to do is, with respect to guardianships, is have temporary guardians appointed. We've had situations where we've had residents who've had real property that, and they're not able to get on Medicaid. We would then get a temporary guardian appointed, have a mortgage executed by the temporary guardian in favor of the facility, and then get that individual on Medicaid. And then at some point thereafter, have the guardian then sell the property, use the property, the proceeds from the sale to then pay back whatever viable medical bill may be outstanding for the facility. The other thing that we've also been able to do with respect to guardianships, there's a cost associated with guardianships. There's a court evaluator to be appointed, there's a court-appointed attorney. We've been successful in many cases to get the costs and fees associated with the guardianship proceedings recouped by the nursing home out of the assets and or income of the resident. One of the things that I want to mention real quickly is with respect to participating provider agreements. As Raul has mentioned, there is this obligation with respect to making NAMI contributions. There's been discussions that the NAMI payment may be something that it will be taken over by the managed long-term care plan. They'll handle the NAMI obligations, the monthly income contribution. And ultimately, the discussion is that that will become a state responsibility. That isn't, we're not there yet, but there's discussions to this effect. Well, what we're also encountering, and we're hearing discussions, is that the managed long-term care may actually assign that duty and obligation back to the nursing home, which is what they're doing today. They're responsible for collecting the NAMI contribution. And one of the things I want to bring to your attention is when we're looking at these participating provider agreements with MLTCPs, there is a clause in there which is referred to as no recourse. And I'm just going to read very briefly a sample of one of these no recourse clauses, which basically states as follows. The provider agrees, that's the nursing home or the facility, that in no event, including but not limited to non-payment by the plan or insolvency by the plan or breach of the provider agreement by the plan, shall the provider bill, charge, collect a deposit from, or seek compensation or reimbursement or have any recourse against the participant or his or her eligible dependents or any person acting on the participant's behalf for covered services provided pursuant to the agreement for the period covered by the paid participant premium. So that's a very important clause that we're going to be encountering and looking at in these MLTCP plans. And we have to recognize that if we have an obligation to collect the NAMI from the resident, this kind of conflicts with that concept. How are we supposed to recover the NAMI from an eligible participant or from their family members or legal representatives if we have this clause in the paragraph? So we may have to negotiate that type of NAMI contribution either being on the clause or negotiate this particular clause being on the contract. It's going to be very difficult to do because we're seeing these in many of these types of agreements.
Mark, you also have, there's a hornet's nest of problems here. First of all, the managed care contracts we've seen are all over the place. So they have provisions that prevent the provider from recovering from the individual because, you know, the individual needs to be protected. But we also have provisions that allow the managed care plan to retroactively disenroll an individual if there is a determination that they were incorrectly enrolled. So we've been looking at a particular provision that's coming out to allow individuals to be in a plan. However, something comes up with regard to their 5-year look back, for example, that there were transfers of assets that were not taken into account. They could be retroactively disenrolled. The managed care plan could then say, well, we have a provision in our contract that says that they were enrolled incorrectly, so we're going to take back all the money we paid you for the last 5 or 6 months. Now, you know, that's a very difficult situation. The only way to really plan for that is through your intake procedures and the admissions process. Going back to the HMO addendum that I had referenced as exhibit or attachment D, which is a separate addendum that we've been recommending to our clients so that you capture the ability to go back and say, well, all bets are off now. We found out that you transferred this house. The managed care organizations, you know, picked up on that, and now guess what? We're going to be suing you, you know, for that care. There's also a financial questionnaire that we recommend so that individuals tell us about inappropriate transfers, and if they lie, of course, that's a issue of fraud. So it really is a hornet's nest in terms of trying to prepare for this, and I go back to the regulatory requirements, trying to assure that facilities use those regulatory requirements in their, to their advantage. I didn't mention the MDS procedures, but MDS, minimum data set, is required across the board. It's used for payment purposes on the Medicare and Medicaid side. A couple of years ago, they revised the MDS to, with MDS 3, and there's a new section Q that was added to that to bring to the fore community-based planning. And I think this is going to be critical, that everyone in an organization really needs to be part of a team to assure that you're doing things correctly. You slip up, any member in that team slips up, and there could be a gaping hole financially for the organization. So discharge planning begins at the time of admission. And Section Q of the MDS 3 focuses in on that. Where are you going to go once your stay here at a institutional-based setting ends? There is a referral requirement so that the nursing homes where MDS is required must refer out to community-based organizations to find supportive housing. So you'll see the supportive housing concept is going to be pushed by the administration, both with money and with mandates. I didn't mention the interdisciplinary team. The whole concept of managed care is to manage care and manage money. And borrowing from what the nursing homes have been doing since 1986, there's this concept of interdisciplinary planning. So that concept will now be extended from the nursing home into the managed care, actually be driven by the managed care care coordination nurse in terms of the planning for care. Very critical to understand the interplay between licensure requirements and managed care mandates. You have a contractual requirement with the managed care organization to abide by now the interdisciplinary team decision, which is going to be made by the managed care entity. We also have a requirement to serve the needs of the resident. And if you don't do that, you could very well be in jail. So if you discharge someone without a safe discharge in place, you risk immediate jeopardy. And under the Elder Justice Act, if you intentionally caused a harm, there may very well be an investigation by the Attorney General with potential criminal consequences. And unfortunately, those two sides of the state and the federal government have not addressed that sword of Damocles that hangs over the care providers. And you see that in the OPWDD side as well with the Justice Center. There is a developing enforcement mentality, which is justified, but sometimes it's over the top, based on the individuals that are doing the enforcement. And all of that needs to be integrated with the payment side and the managed care organization. Managed care entity could go into bankruptcy, and hopefully they've got the reserves to pay out the claims that may be pending while they've been having financial distress. But you don't have the licensure and enforcement teeth on the managed care side. That teeth is on the provider side, on the licensure side. Now, we've set aside some time for questions. I'm not sure if you've gotten any questions or any questions from anyone in the room here. Yeah, I think we can pass it over to Jerry.
All right, thank you, Raul. Good morning, everyone. As Kathy Purdy indicated, my experience is primarily in the healthcare field for the last 40 years now, and working almost exclusively with providers. And my message for you this morning in the hour that I have is that after 40 to 50 years of long-term care providers needing to react to the Department of Health with respect to how rates are established and how they're going to be paid, this new environment of managed care requires long-term care providers to be more proactive than reactive. And I think Raul and Mark have done an excellent job in articulating and describing many, many of the issues that result from this initiative on the part of the state to implement managed care reforms throughout the long-term care service sector. The PowerPoint presentation that you have in front of you labeled Preparing for Managed Care under our logo, the Bonadillo Group, contains far more information and material than what I can cover in simply an hour. I put it together primarily not only for the benefit of the participants, but even more so for your board members, your senior management team members, and your department heads. There are no copyright restrictions on this in any way, shape, or form, so you should feel comfortable in providing this information throughout your organization. And as I've said to many audiences, I believe that it's clear that the folks that attend these webinars have heard this so much, they're almost numbed to the thought of what managed care in New York is doing with respect to long-term care implementation. But throughout your organization, there's far more importance that your respective boards, management team members, and department heads have a much clearer picture of just how the rules of the game are being changed. And as the rules of the game are being changed, it's shifting a lot more responsibility to the provider community to react, if you will, to the changes that are being implemented. Essentially what the state wants here And I'm going to take a deep dive, if you will, in this next hour into what I think those proactive responses need to be. The state wants the most efficient delivery of necessary services in the least costly setting. That's their definition. They won't publicly state that definition, but that's essentially what managed care means. So to repeat, most efficient delivery of necessary services in the least costly setting. Now, what that generally means to you as long-term care providers, and I'll use the visual of the screw. You can interpret it any way you'd like. I'm interpreting the screw as being a reduction in revenue from the Medicaid program. And this is a program that, as Raul and Mark have indicated, is generally paying you substantially less than your current cost of services. In most homes across upstate New York, you're anywhere from $50 to $75 a day underfunded in relationship to the costs that you incur to provide services to Medicaid recipients. So for the state to be implementing managed care and thinking that the long-term care providers have more to give in the Medicaid arena with respect to revenue, I think is flawed logic, and that's what we hope to avoid by virtue of going through some of these proactive responses that we are presenting to you today. So the message is we want you to be very, very proactive, and we're going to discuss IPAs as one model for long-term care providers to, if you will, level the playing field and establish a bit more leverage than what you might have as an individual provider. And also wanting to make sure that you understand that as opposed to your previous relationships with the Department of Health or Office of Health Systems Management at the Department of Health, you are now going to be dealing with a variety of intermediaries, whether they be managed long-term care plans, performing provider systems, accountable care organizations, behavioral health managed care plans, etc. And every long-term care provider needs to have a dedicated team devoted to provider contracting, which is a very, very different environment from where we've been for the last 40, 50 years. So I think that is very important at the individual provider level, and also something that is of benefit if providers join together in an IPA, one or more IPA structures as members. The state of New York has a magic wand with which they expect to achieve this reduced costs, least costly setting, only necessary services being provided, and the magic wand is referred to as care management. What we've all referred to for the last 40 or 50 years as case management, they've defined it as care management. About 2 weeks ago, the Department of Health put out an updated timeline. This is just a portion of that timeline. You go on the website that's indicated here, you'll be able to see from 2010 forward the various populations that have been put under, if you will, or intended to be put under some form of different type of care management than what's been applied in the past. And you can see on this slide and the next slide, what I try to do is pull those timeline implementation dates, as Raul said, always subject to some form of change, but pulling those that are relevant to particularly long-term care providers. Whether or not care management and the magic wand, if you will, that the state believes is being implemented, what I refer to as case management on steroids, whether that's going to work in an environment where we're in the most regulated state in the country, without any kind of regulatory relief, again, as Raul and Mark both indicated, with respect to the level of issues that you have to deal with from a compliance standpoint, is yet to be seen. I'm not particularly optimistic that it's going to work as smoothly as what the state might believe it will, but that doesn't mean that we can sit back as providers and not try to be responsive to the changing nature of how the structure of the long-term care sector is going to be reimbursed on a going forward basis. Raul already went through his predictions with respect to when the implementation for upstate providers, April 1 of 15, is going to be fully implemented. But for anyone to think that it's not going to happen at this point, I think they're being foolish. Whether or not it's going to happen by April 1/15 is another matter, and it could be further delayed. But all that is an advantage for providers to get yourself more prepared for the inevitable date of implementation, both for care management as well as for the contracting with the various managed long-term care plans. So as you look at those dates, the only thing that's really of benefit to us so far, in my opinion, in the long-term care sector is the repeated deferrals of implementation dates. And in part, and I think Raul mentioned this, it's not unreasonable to think that the state has deferred on these implementation dates because they don't necessarily have all of their act together with respect to being able to have what they consider to be a smooth implementation. So further delays are to our advantage. The longer we go in our current structure in terms of reimbursement, and particularly for residents that are in-house and new admissions coming into the house, the better off the providers will be in terms of preparing for the inevitable implementation. What I'm going to do now is very, very quickly give you what I consider to be my top 10 list of managed care facts. Most of you have probably heard some or all of these in some way, shape, or form in other presentations. Again, I can't emphasize enough, this presentation is put together for easy reading, if you will, for board members, senior management team members, as well as department heads. And I think it's very appropriate that you make this available to your organization and those members within your organization. I'll refer, the second bullet on this slide, I'll refer to vulnerable populations several times in the next 30 or 40 minutes. There are 5 vulnerable populations that the state is now moving into the managed care arena. The frail elderly, which is the long-term care and the home care population, is the largest of these vulnerable populations. The mental health population, the substance abuse population, the developmentally disabled population, and they still haven't quite figured out what to do with at-risk youth, but that's the 5th, if you will, that will be addressed at some point in time in the future. And as you look at those implementation dates, you can see services related to youth are the last, if you will, in terms of implementation dates. So vulnerable populations, by definition, are high cost, don't necessarily have full control over their faculties with respect to what costs they are going to incur, and are in many cases not in a position to improve their relative health position. So they're not exactly what you would consider to be the ideal population by any stretch of the imagination for implementing into a managed care structure, which, as you may recall, back in the 30s when Kaiser first developed the HMO model, health maintenance organizations, the idea was that you needed to have a population of relatively interested individuals with respect to improving their health and wellness. You had to have individuals who would respond to initiatives relative to care management and case management, and by all means you had to have a large enough population, in most cases 5,000 to 10,000 individuals, to be able to spread the risk associated with any kind of a capitation arrangement. In our particular situation, none of those 3 criteria apply, so that makes this implementation of managed care for long-term care all that much more difficult. The last bullet on this slide, it appears as though the state, while it's not published, it appears to me as though the state is looking initially in the long-term care population at any individual that's incurring more than $150,000 of Medicaid costs on an annual basis. That's across the entire spectrum of services, not just what you're billing as a nursing facility, but what they might be incurring in ER visits, hospital admissions, readmissions, etc. So don't be misled by the fact that we're looking at this as a full implementation of all individuals covered by Medicaid. We are looking at that, but the focus is clearly on those individuals that are in the high-cost population. 150,000 is what some folks, myself included, feel they're looking at first. I think that's ultimately going to be reduced to 100,000. and then the folks at the lower end of that spectrum are going to be obviously much less interest to the state unless they are frequent in terms of their utilization of services at hospital facilities, which are also being forced into some significant changes as a result of the DSRIP implementation that Raul mentioned. I have here on this slide a shortened version of the acronyms that Raul and Mark provided to you in their materials. I must say that their list of glossary of acronyms is quite thorough. I did just mention DSRIP, Delivery System Reform Incentive Program. I think everyone knows that the state government agreed with the federal government that in return for $8 billion, which is really $6 billion over the next 5 years, because $2 billion of it's going to go directly to state-operated facilities, that $6 billion is going to be received by the state of New York for implementing system reform only if we reduce avoidable hospital admissions, ER visits, and readmissions by 25%. Now, I doubt that I have any hospital CEOs participating in this webinar, but if I did, I can tell you from talking with them directly, they're not particularly thrilled about a 25% reduction in avoidable, well, let's figure out what that definition is going to be, avoidable Medicaid utilization of hospitals might be. So we are in a period of time where we've got a clash that's going to occur between and amongst the various providers that on the slide that Raul presented that showed that integrated delivery system that the state is trying to achieve. What the state fails to give recognition to, even though they know it's there, is that each of those providers have a very, very significant mission on their hands, whether relative to providing services and maintaining fiscal viability. So when you start talking about fiscal viability, you're going to obviously talk about which piece of the pie am I going to be able to obtain as a provider, and that's the big issue that we have to deal with in the long-term care sector, representing ourselves effectively to make sure we get a fair share of the dollars, not just the DSRIP dollars, but the Medicaid managed care dollars that are being allocated by the Department of Health to the various managed long-term care plans. I will mention later on the structure of an independent provider association, what used to be called in the physician arena as an individual practice association. Same basic concept, developed initially for physicians back in the 70s and 80s, now has morphed into the provider arena as independent provider associations. You will be faced over the next 12 to 18 months with contracts coming from not just managed long-term care plans, probably as many as 4 to 6, depending upon where you are in the state, and I'm referring primarily now to the upstate population. IPAs have been very popular for the last year and a half in the Metro City area, so those folks on the phone that are on the webinar that are from the city are very familiar with the multitude of IPA structures that have been developed down in the metro area and on Long Island. You're also going to be approached by what are now referred to as the PPS group, the 37 or 38 organizations that have been awarded planning grants to develop what are called performing provider systems. For many of you, PPS used to mean prospective payment system. The state was told that they were confusing people with the PPS acronym, so they added an E to the front end. So they now sometimes refer to these as emerging performing provider systems. They are one and the same, but you hear PPS much more than you hear EPPS. And then further down on this list, all of the accountable care organizations that are being formed under Obamacare are also forming what are called ACNs, Accountable Care Networks. So you've got potentially anywhere from 10 to 12 different contracting entities that will be approaching you as a provider for purposes of wanting you to become a participating provider in their network. The question on the table is, do you want to do that as an individual provider, or do you want to do that as a regional provider network? And that's the basic message of what I have here for you today, is to make sure that in dealing with this multitude of fiscal intermediaries, which are defined on this slide, every one of those 10 to 12 fiscal intermediaries coming to you are going to be trying to balance what the state has allocated to them in terms of a capitated enrollee rate with what they can afford to pay you. And unfortunately, the state is starting with, as Raul indicated on his slide, the state is starting with current Medicaid costs, which, as I mentioned, for most long-term care providers are $50 to $75 a day, less than your true cost of services. So if that's their starting point for capitation, and then you have to take out for the various contracting intermediaries their administrative costs and their contracting and their desire to add to their reserves, or in the case of the for-profits, generate profits, it leaves less money available for the long-term care Medicaid service providers from each of those contracting entities. And so it's very, very important that when we move forward in terms of looking at, do we go forward individually, do we go forward in some form of a merged or affiliated system, much like the hospitals have done. The hospitals have been circling wagons now for the better part of 10, 15 years. I think the situation in Utica, where St. Luke's and St. Elizabeth's has been granted authorization to become one system in an urban area, granted not the largest urban area in upstate New York, but one system on the hospital side is the profile, I think, of what you're going to be seeing in the future in all of the various service sectors. Ideally, the state wants to maintain 2 in each major urban area in terms of provider networks, and that's why I think that you are not going to be participating just in one IPA, but perhaps 2, in some cases, depending upon your geographic footprint, maybe 3 IPAs. So the vulnerable populations, this applies to all of them, but we're specifically referencing today the long-term care sector. This next slide, again, for purposes of board, senior management, and department heads, the state also believes that this cost reduction that's going to occur, even though I've just described to you the flawed logic of starting with a Medicaid cost that's less than your current cost of providing services, you can only shift so much more of that to the private pays and the commercial insurers and generate more dollars from the Medicare program than what it might cost you to provide therapy or rehab services. These are the 12 most common areas that are looked upon as being potentially beneficial for purposes of the state's desire to reduce administrative costs in an organization. Now, again, there's a bit of flawed logic that goes into this list of 12. I'm not a government agent here. I'm speaking from the provider side of the house. I do believe that every organization in the long-term care sector needs to decide whether each of these 12 areas, one, is it a core competency that we are providing as efficiently as we possibly can? 2, if it is not a core competency, how can we acquire this competency from an outside source at a lesser cost than what we're currently incurring? And 3, does it make sense for us to join or participate in what's now called an MSO, Management Service Organization? In the 80s it was Shared Service Organization. In the 70s it was Administrative Service Organization. So if somebody comes to you and says, we're putting together an ASO, an SSO, and MSO, they're talking about all the same type of, if you will, structures to come together as groups of providers to try and develop more efficient approaches to developing these services. I would say the most common one that has had the most success, primarily because it's funded in the form of grants, not just meaningful use, but also grants that the state has set aside, is the area of information technology. They are of the opinion, the state of New York is of the opinion that part of the magic wand of achieving cost efficiency is going to be real-time data on a technology end that's going to allow the care managers to make the decision of whether or not Jerry Archibald can be triaged in the nursing home resident bed, or whether 911 should be called for an ER transport or for the potential of a hospital admission. That's their concept of avoidable hospital admissions. avoidable hospital ER visits, and it all comes down to having data on a real-time basis and having a decision maker that is in authority. One of the problems of this particular implementation that is currently in place is they haven't dialogued very much with the physician community. Physicians are not particularly anxious to be saying to a nursing home that you should not send that resident to the ER, but nonetheless, that's part of this process that involves a lot of ethical, moral, legal, potential litigation, malpractice issues associated with it. So I don't mean to imply in any way by this slide that we are in an easy mode of being able to accomplish these efficiencies that I'm talking about. But I will say that probably half of these have some significant traction and legs with respect to being more efficient than you doing it on your own. IT would be number one on the list. I would say compliance, managed care provider contracting would be second and third. And then the idea of facilities, occupancy, and maintenance, I think many of you are doing some of those things already. Early on, and I think many of long-term care providers are still, we started in the laundry and linen arena, and we started in the group purchasing organization participation. Those were the two most prevalent, if you will, participation in some form of management service organization activity. So that leads us to that challenge of reduced Medicaid revenue in an environment where we're already, I'll use the term, getting screwed in terms of what the dollars are that are being paid in relationship to the dollars that are being incurred to provide the care. That gets us to the Independent Provider Association, which is defined here as an individual group of healthcare providers, in this case long-term care providers, but it doesn't have to be restricted to a specific sector like long-term care. You can have multiple disciplines operating within one IPA. That IPA is under contract to provide services to the members or enrollees of different MCOs, managed care organizations, other insurance plans, and we have to add PPSs and ACNs into this mix now as well. So that's where I get to that potentially 10 to 12 contracting agencies that you'll have to deal with. And as I said to Raul before this webinar started, the benefit of an IPA is not on the rate side. The state is guaranteed, to the extent a state guarantee can be relied upon, the state is guaranteed that your published Medicaid rate is the floor that you're going to be paid for the first 3 years of managed care implementation. So this is not about getting a lot more money on the rate side. In fact, the best negotiated contract that we've seen from any long-term care plan, and it was a unique set of circumstances, was published Medicaid rate plus 20%. Not bad, but that was a very, very unique situation. The vast majority of the MLTC plans are saying, listen, we're getting what you're currently getting paid in capitation. Not true. We're only going to pass to you what they're paying you in your published Medicaid rate. So that's where the negotiation of an IPA becomes very important from the standpoint of, can we enhance our rate, or more likely, can we tap into what's called the pay-for-performance pool, P for P, that is being established just within the last 30 days. We're finally starting to hear the MLTC plans acknowledge that they are willing to look at groups of long-term care providers who are willing to initiate programs that would reduce hospital ER visits, hospital admissions, and hospital readmissions. Those are the same 3 objectives that started in the employed model of HMOs back in the 70s. They remain today, 40, 45 years later, as being the same 3 objectives for managed long-term care. I will tell you that the average upstate admission is somewhere between $15,000 and $20,000. If you can reduce the admissions that are coming from a group of long-term care providers to achieve the 25% reduction that the DSRIP commitment to the federal government made, you are going to be rewarded for that. And in most cases, the MLTC plan should be expected to provide to the group, the IPA, 50% of that savings. Now, there are other models that are being considered. beyond just the negotiated IPA MLTC model. But you can see that there's a significant amount of potential dollars there if we are, in fact, able to achieve those reductions of 25% over the next 5 years. So as a vehicle, I am absolutely convinced, have been involved with IPA since the late 70s, early 80s with the physician arena. Largest IPA that we represent includes 2,200 physicians and 700 allied health professionals in Rochester and the surrounding 9 counties. And you might say, well, how can you have 2,200 physicians in an IPA without violating Federal Trade Commission or antitrust rules? And the key there is there's another organization, another IPA, so there are 2 IPAs competing with one another in that same 9-county region. There are now 4, actually. We started with 2. We now have 4. And that alleviates that, if you will, pressure from the Federal Trade Commission to some degree. I'm not a lawyer. I'll have to refer you to Raul and Mark for discussion on the FTC side. But I will say that the environment that's being created by the state of New York is clearly directed at providers collaborating with one another. I think most of you have seen Governor Cuomo's edict that if a single provider comes looking for a grant from the state of New York, whether it be VAP, BIP, IAAS, or whatever other sort of BizRIP grants might be available, single providers are not going to be looked at. They go either to the bottom of the pile or to the circular file. So an IPA is a structure that allows for collaborative grant applications to be submitted and hopefully obtain a more significant attention and potential for a positive award.
That's a good point, Jerry. The first question that's asked when I go through this with individual clients is, what do you mean by collaboration? And then the next question is, after they understand what collaboration means, how do we get paid for that? An IPA is an excellent vehicle to understand that concept.
Right. We're going to talk a little bit more about how the structure of an IPA, a lot of people back off from IPAs because they think they're very costly and very expensive to both create and operate. That is absolutely not true. Raul used the term virtual IPA before the webinar started, and that's more of the model that's really being created now, which is a very, very low-cost model from an administrative infrastructure standpoint. So on this next slide, and again, I'm going to go through not all of these, but the ones that I think are most important to at least comment on. First bullet here under item 2, you absolutely have to have a multidisciplinary provider contracting team for your organization under managed care. If you think the CFO or the CEO or some other individual in your organization can do this contracting on their own, disavow yourself of that notion right now. It has to be integrated between the operating side of the house, director of nursing, the CEO, the CFO, whoever you feel is most relevant. The IT should be involved. Compliance officers should probably be involved as well. And that's where, rather than having 300 nursing homes upstate all create their own individual provider contracting teams, if those 300 nursing homes form, let's just pick a number, 50 IPAs of some varying degrees or numbers of participating providers, you've got a much more efficient structure for purposes of negotiating with the long-term care plans, the PPSs, and the MCO and the ACNs. And I might add, having dealt with anything from Excelis to Aetna to Cigna to Fidelis and all of the other insurance companies licensed in the state of New York over the last 40 years, they actually prefer to not have to deal with you as an individual provider. They would much prefer to deal with a group of providers because it's a lot less administrative time on their part, a lot less negotiation of individual contracts, a lot less in the way of fees associated with preparing those contracts. So you might think that they're against this collaboration and regional provider network structure. They are absolutely not. Not that they're going to necessarily embrace you with open arms and give you everything you want, but they are definitely going to see the advantage of having a collaborative group working together rather than trying to achieve some specific reduction in those ER visits and admissions on the part of an individual provider. So the last bullet on this slide, remember that managed care at its core, a negotiated rate-based financial risk model. We got 3 years of protection from our current published Medicaid rates. So what we're ultimately going to get to, and you've got basically a 3-year window here to get your act together to be able to be in the structure strategically that you want to be in for when that rate negotiation gets lifted, or that protection, I should say, gets lifted 3 years down the road. The most common structure, as I say, has been, will continue to be, I believe, the IPA, or what are sometimes called RPNs, Regional Provider Networks. And we do not want providers in a long-term care IPA to take any degree of financial risk other than on that pay-for-performance side of, if we reduce hospital admissions from 2013 to 2014 or 14 to 15 by 10%, we want a piece of that pie. If our hospital admissions goes up, we're going to suffer a penalty. And that's one of the requirements of an IPA. You have to have risk in order for an IPA not to be in violation of FTC rules. But that risk does not have to be accepting a capitation rate. So I don't think you're going to see any substantial shifting of risk. I think where the opportunity is for next year in 2016 is likely in the pay-for-performance areas, reduced ER visits, admissions, and readmissions. And what we're hearing from a number of the plans now is a willingness to create quote-unquote pilots with certain groups of providers who are interested in implementing procedures and initiatives to try to reduce the level of utilization of the hospital facilities. Now again, on the other side, the hospital facilities, they're not all that crazy about reduction in their revenue utilization from admissions and ER visits, so that's the initial clash or conflict that we'll have here as we go into this process. I will say that the individual homes or the groups of providers that come together in a network, whether it be an IPA or a regional provider network, everybody that joins an IPA should know, at least for 2013, how many ER visits, admissions, and readmissions were generated from your population that you serve. Many organizations have that data within their organization. It's not necessarily readily available by pushing a button, but you can get it. And the reason you want to have that is you want to be able to go to a plan and say, this group of 10 providers generated 3,300 ER visits and 1,200 admissions last year. We think we can reduce that by 5%, 10%, whatever the number is that the group feels is appropriate. And that's your pitch to the MLTC plan. And they're going to be salivating on the other side because they're paying on the other side for the ER visit and the admission. And if you can avoid a $15,000 to $20,000 admission or more, or with the average $1,000 to $1,500 ER visit, that's big money to them. So that's a very important aspect of what we're trying to move forward here. The last bullet was put on this specifically for board members and management team members that a lot of nursing homes participate in workers' comp trusts and have been subjected to joint and several liability issues as a result of being hoodwinked into joining self-insured trusts back in the 90s and 80s. This is not about joint and several liability. IPAs, you are evaluated on the basis of your performance as an individual provider, not on the basis of the joint and several liability or associated with the other folks that you're in the pool with. And that's a very important concept to be remembering. So over time, we are going to move from fee-for-service, which is currently 100% of your reimbursement. You get very little. You may get some grant money, but very, very little is going on right now in the pay-for-performance arena. But the third to last bullet here, within 5 years, 92%, I think, of your revenues are going to be generated from rates, negotiated rates. The other potentially up to 8% of your revenue is going to be generated by pay for performance where you are effectively creating efficiencies and cost reductions for the plans, and they're going to push back to you dollars through your IPA to reflect the savings that you have generated on their behalf. Now, it's not just ER visits, admissions, and readmissions. Every one of these plans has a whole slew of target measures that they're trying to implement. But the first three that you want to talk about, because they're most easily measurable, are the three that I've been mentioning. But there will be others, there's no question, because all of you are measured now, and it's published data with respect to outcomes, quality of service, etc. And I think those will become part of this pay-for-performance model going forward as well. Very important, the last bullet, IPAs do not have to be subject to Article 44 insurance regulations in terms of the onerous reserve requirements in order to get an Article 44 license. And the reason for that is you are not taking the same type of risk that qualifies as insurance risk. You're taking performance-based risk that is essentially either an add-on or a discount to the revenue that you've previously received. And that's very, very different from an insurance risk. Now, if you go to a capitated environment, then that's a whole other kettle of fish where you have to get involved in establishing reserves through withholds. Still not subject to Article 44 unless the state changes the rules, but when you get into capitated environments, it's a different structure in terms of how those members are going to be, if you will, funding the potential for a excess cost being incurred in relationship to the capitation amount that you agreed to. Right now, they do require a certificate of authority from the state of New York to operate, so this is relatively recent. As the proliferation of IPAs down in the city was created, the state now does have a process where attorneys have to submit a variety of data, articles, and corporation bylaws, operating agreements to make sure that you aren't an insurance company in disguise. They want you to be functioning as a true IPA structure, which is a contracting entity as opposed to an insurance entity. I do believe, and this is part of the reason why these DSRIP planning grants were just awarded within the last 2 weeks, all of the PPS DSRIP planning grant awards are due to, the plans are due to be submitted to the state of New York by December 16th for their review and approval and further awards. Each home in New York State, long-term care provider, should be associated with at least one of those award recipients and most likely two. And again, that's another means of the state being able to satisfy the federal government that we are continuing to allow for choice on the part of the resident or the individual patient. They're not going to be funneled into just one system. They have a choice of two systems when it comes to the ultimate integration of the PPS. Talked about the DSRIP monies, and certainly it sounds like a lot of money, but when you spread it around New York State and you understand that $6 billion is going to be determined on the basis of annual performance. The state just hired a company out of Boston called Public Consulting Group. Public Consulting Group is known nationwide for evaluating these types of programs, and every year they have to represent to the federal government that the state has achieved the goals of reducing the hospital utilization by that 25%, along with other goals and objectives that we're committed to in DSRIP. So just because they say we've got this money, we don't have it until we actually demonstrate that we've achieved the performance goals. I talked enough about care coordination, case management. In the second bullet here, that should have said LTC providers, not BH providers, but you can see that this care management case coordination is being applied to all of the vulnerable populations. Behavioral health is right in the same sequence right now as the long-term care population. The next to last bullet, again, for purposes of your board to understand, this is largely about high-cost recipients of Medicaid eligibility and not what they necessarily want, but we're going to have a decision made by care coordination and case management and care management. We're going to have that decision made for them as to what they need. Now that's going to generate a fair amount of angst on the part of the recipients and the residents as well. So it sounds great in theory, but when you get the pushback, you realize just how complicated this could become. And that's what I say on the bottom. The challenge for providers is walking that fine line between making sure that you're providing the necessary services that are not going to result in some form of litigation or a malpractice allegation or negative media coverage for somebody having to die in the home that somebody says and a family member happens to say that individual should have been transported to the ER. And we're seeing that even in today's news, and every day that seems to go by over the last 2 weeks, somebody's been killed in some kind of an environment, the most notable one being the chokehold by the New York City police, where that family is clearly going to have a litigation against New York City police as a result of that action, caught on video, I might add. Okay, Raul talked about the dual eligibles. They are, without question, the highest cost component within the Medicaid eligibles in New York State. So that's where those FIDA plans, the fully integrated dual eligible programs, are going to be implemented. We have essentially one FIDA downstate that's operational, and the state is moving very quickly to license additional models as well. And I think for those folks that outside of the group that is listening to this presentation, the board members, the best way for you to describe what this is all about, the analogy is in a medical model on the fourth bullet there. Should a patient receive an MRI versus a CT scan versus a PET scan, or who is entitled to joint replacement surgery based on the age of the patient? Those are the kinds of questions that societally we're going to have to start deciding upon. I just heard yesterday about an 87-year-old getting a new set of heart valves. My own personal opinion as a taxpayer is I don't know anything about that 87-year-old, but I'm not sure the government can afford to replace every one of the baby boomers' joints, shoulders, elbows, knees, hips, and now advertising ankles, I might add as well. It's just not a functional, viably process from a financial perspective to expect that's all going to be available. So the emphasis has got to be, and this goes back to the proactive nature that I talked about earlier. Most long-term care providers will tell you that they're operating at the bone or at the nerve level already because of the last 30 years of the pressure from Medicaid, but yet the state feels there's still more opportunity for cost reduction, cost effectiveness. And again, the two options that are out there right now most likely are the pay-for-performance dollars by essentially taking money from the hospitals, giving it to you as the nursing home or long-term care provider, and then the MSO shared service model that I talked about earlier in terms of reducing the costs associated with your administrative support functions. I've talked about conflicts of interest and ethical issues. There's a whole industry being created right now in this country that's advancing rapidly beyond just bioethics into some of these issues that relate specifically to managed care. The last bullet is also important. Virtually everybody in your organization is going to require substantial retraining because they're not going to understand why this major change of shift of emphasis on avoiding the hospital is something that they need to be participating in. Who's going to take responsibility? It should ultimately be the physician making that decision. Physicians are not anxious to make that decision, so figuring that out between the physician, the care manager, and the folks that are providing the direct services at the facility is going to be an interesting discussion and resolution. So you have to understand that the MLTC plan is correct when they tell you they're getting a capitation rate per enrollee per month from the state. What they don't tell you is that there are add-ons to those rates for both administrative costs as well as in many cases, these pay-for-performance models. And the historical value of adjudicated claims, we know, has very little relationship to the actual costs of the service that you've been delivering. And that's something that, while the MLTC plans understand that, you have to consistently hammer at home when you're negotiating with them that you're starting from a published Medicaid rate that is $50 to $75 below where it needs to be. Smaller providers linking with larger providers should consider the formation of a regional provider network, either an IPA or a joint contracting LLC. And these are the three reasons most notable for why you want to participate in a network. Makes you too big to ignore by the MCOs and the MLTCs, too big to exclude from their provider networks, and provides its members with additional negotiating leverage. You can use the union analogy to this. This is not a union, but it is a joint contracting entity coming together for purposes of achieving financial pay for performance, and you also have to be involved in clinical integration and financial integration in order to pass the tests of the anti-competitive behavior under the FTC rules. And we'll talk just a bit about the clinical and financial integration requirements. This we've said before. Basically, you're going to be offered less than what you are going to need in terms of your cost. Not too different from where we've been for the last 40 years. But as Raul said, the ability to continue to shift this subsidy onto the private pay population and to the commercial insurers and to the Medicare program, it's not a viable model going forward. So somewhere we got to have a rebalancing of what comes from the Medicaid system to maintain the viability of the long-term care providers. So in the middle of this slide, under the second bullet, everybody should be asking the question or already having answered it, but continuing to ask it each year. Does your organization want to maintain an individual autonomy, or is it more feasible to merge with or be acquired by another organization? That is your service niche exceptional, or is your organization already too big to ignore as an LTC provider? There are certain providers in this state that have certain niche services, whether they be Alzheimer's, behavioral health units, developmentally disabled units, that these plans have to contract with. If you happen to be in that favorable situation, you may not want to join a network, but my personal opinion is you're almost always going to be better off in a network than you are negotiating on an individual basis. The areas that you need to look at in addition to a provider contracting team that I mentioned earlier, your cost accounting systems are going to have to be much, much more sophisticated for purposes of being able to determine how much does it cost to provide services to high-cost individuals. Ultimately, we are going to have reimbursement for cost outliers in the Medicaid population. It's inevitable. Happened in the Medicare population, going to happen in the Medicaid population. Medicare can't sustain a cost outlier on the federal program for Medicare without having to apply something similar in the Medicaid arena. So cost accounting systems are very, very important. All of you have moved in the direction in some way, shape, or form on EHR and EMR. More money is out there to fund that initiative. That goes back to this real-time data being available for the care manager, the physician, and the individual at the home that's providing the direct services. Restructuring your billing and accounts receivable systems to accommodate the revised contract payment methodologies, incentive payments, performance goals, and P4P. And then, as I mentioned earlier, trying to generate as much as we can in terms of efficiency and administrative costs. So all of that is intended to provide you and your board, management team, and supervisors with the logic behind why an IPA structure is appropriate. The last one that I'll use, these are Jerry Archibald's 5 R's, nobody else, but you can expect to see restricted access, challenges to service eligibility, that would be the trip to the ER being an example of that, relocation of service delivery sites, pressure to get people out of both the hospitals and the nursing homes and into home care services or the least costly site of care. Rationing of services through care coordination, that's going to be subtle, but it's going to be there. I don't know how overt it's going to ever become because of the potential for litigation. Part of this whole managed care process is redistribution of the Health and Human Services budget. Nursing homes and hospitals are in dire straits across the state for the most part, and the state does not want you to default on state-backed debt that you might have obtained through DASNY or some other state-backed financing activity. So some of these dollars are being redistributed to try and keep you in a viable form of business. The best example of that was the VAP application that was provided to the 4 nursing homes in the northern Adirondacks back in April. They received $7 million. $5 million of it was to shore up their financial conditions so they weren't going to drive off the cliff. $1 million for information technology. $1 million for developing a shared governance structure. These 4 homes are 60 to 80 miles apart, and they're supposed to have one governance structure, I think, within the next 18 months. So that tells you where the state and the Department of Health is going with respect to collaboration, regional networks, etc. Last one is not about Sarah Palin and pulling the plug in the death panels, but inevitably, if we're going to talk about reduced emergency room utilization and inpatient admissions, one thing I like to say, and it's a crass way to say it, I'm not necessarily implying that this is an appropriate thing to say, dead people do not incur medical costs.
They do incur malpractice costs.
They do incur malpractice costs, yes. Thank you, Raul. But that last one is where the ultimate conflict is going to come into play between the legal profession, the medical profession, and the state of New York. How far are they going to push in this direction of reducing avoidable hospital ER visits and admissions? And that's yet to be seen. It's talked about conceptually. Raul mentioned the 2005 study that showed that there was a $10 billion of savings out there that they could quantify. That was 10 years ago. That number is far greater today than it was back then. And so this is going to be a very, very significant issue for organizations to move in the direction of trying to create the efficiencies that the state of New York is looking for. Okay, so very quickly, I've provided you with the argument for why a network in the form of an IPA is most appropriate in our opinion. You will not be exclusive in most cases to one IPA. There will be 2. I'm currently working on 12 IPA development structures across upstate New York in various service sectors. That's not all long-term care. In fact, a minority of those 12 are long-term care. Long-term care providers have been relatively slow on the uptick to get into this particular model. Behavioral health, substance abuse, developmentally disabled, and downstate south of Westchester County is a very, very common structure. So I am trying to encourage, I'm doing a presentation at Leading Age in September at their conference on this same topic. And so far, Leading Age seems to be getting feedback from the nonprofit members that this is a model that while they're scared of it and they don't quite understand it and they're anxious and frustrated about why they need to do it, they're at least starting to look more seriously at the model. So there are 3 models of IPAs that are out there, and this is normally in the form of a limited liability corporation. Again, members of that corporation are the entities that are involved in that particular geographic region. Ideally, you want to cover 4 counties at a minimum. State would like you to cover up to 12 to 15 counties. That tells you how much they're looking for in terms of single signature contracting when it comes to joint negotiation. The independent model is the one that I generally recommend as being the starting point for long-term care providers, but there are situations where number 3 is a good starting point as well. I'll mention visiting nurse in Rochester or visiting nurse in Syracuse. They have their own MLTC plan that they've sponsored and developed, as well as the Visiting Nurse Association down in New York City. Because they are provider-sponsored, they don't have the same attitude of an insurance company towards long-term care facilities. So there is sometimes more opportunity to do pay-for-performance and structuring pilots that would enable those types of provider-sponsored insurance companies to do more firsthand with the long-term care facilities. And then there are a number of contracts that you'll see where you will, by virtue of signing the contract with the MLTC, they've already created the IPA for you. You've got no representation in the IPA, but by signing that contract, you are essentially agreeing to participate in the IPA structure that they've created. You want to ask a lot of questions about what that means in terms of what that IPA is intended to do and how that IPA is going to be structured going forward. So any one of them can be appropriate, but I would say that the independent model is the place to start in terms of initial evaluation, partnership model being a secondary consideration. Grassroots effort by providers who are also members of the IPA. For example, there's been some discussion on the proprietary homes in New York State under New York Proprietary Association that they would form regional IPAs of the proprietary homes in the 5 regions of upstate New York. The Adirondacks, the Capital District, Central New York, the Finger Lakes region, Western New York, and depending upon where you are, Southern Tier kind of affiliates with some or all of those. Board representation is where the control comes in. It's representatives from the participating provider LTCs. Decision-making authority rests with the IPA board in terms of the negotiation with the various MLTC entities. IRS is not right now granting tax-exempt status to IPAs. They did away with that back in the 80s on a revenue ruling. They're reconsidering it now. I'm hoping that groups of nonprofit tax-exempt coming together in an IPA should qualify as a tax-exempt entity, but they haven't quite got there yet. The MCO negotiations are managed under the direction of the IPA board, independent legal counsel, individuals designated with contract negotiation authority, either from within the organization or outside the organization. And the advantage, as I said earlier, single signature, regional network of providers provide the network for the MLTC or the TPS or the ACN without having individual negotiations with each provider, and it gives a vehicle on which the MLTC plan can start to talk about that group, with that group of providers, about pilot initiatives and implementing procedures to achieve the goals of the DSRIP and the overall managed care initiative. Okay, very important here, second bullet. IPA cannot be formed for the sole purpose of negotiating rates. If you form an IPA and you go to an MLTC and say, we're not signing unless you pay us this rate, that's anti-competitive behavior. However, if you are inclined to assume some degree of financial risk, pay for performance, and you are moving in the direction of clinical and financial integration, which is not very well defined in the antitrust regs, that's where you need legal counsel. You need Bond, Schoeneck, and King to help you with identifying what are the moves towards clinical and financial integration. The two that I can readily give you are going to a common platform for electronic medical records, or at least being able to link the electronic medical records among the group of providers. That's a form of clinical integration. There's a form of financial integration that occurs on the billing side of the equation and the monitoring of the statistics associated with pay for performance. So the bars are not particularly high initially. I imagine that those bars are going to get raised as time goes on with respect to not wanting to have an IPA become, if you will, an anti-competitive model for purposes of structure. But because in the long-term care sector, almost all of your data is published, there's not a lot of secrecy going on with respect to what you're being paid and who's paying it to you. There's a lot of data in the public domain. I'm not going to go through captive, and I'm not going to go through the partnering model. I give this to you, again, as additional information for you to use at your respective organizations. Understand that my strong preference is the independent model, partnership, depending upon what MCO you might be interacting with and whether they approach you on some form of a joint venture for purposes of initiating some of the necessary procedures to reduce the facility utilization on the hospital side. And then this next section, again, since you're not yet at the point where you want to form an IPA, this is information that would allow you to understand a step-by-step approach to forming an IPA. Again, I've been involved with that one that I mentioned with Excelis, Aetna, MVP, et cetera, since 1985. And since the late 70s was my first involvement with the HMO structure that was very popular back then. I will mention to you, and I think this is going to be true in long-term care and Medicaid managed care, the best thing that came out of the HMO model of the 70s, 80s, and 90s, and pretty much everybody's in agreement with this, didn't do much to save costs because insurance costs have been going up by double digits for most of that period of time. Clinical protocols, clinical pathways for following by physicians as well as by healthcare systems. And that same thing is going to be a result here in the long-term care and the vulnerable population. We're going to have much more defined, acceptable standards with respect to pathways and protocols. All right, so then I go into the top 10 issues that you need to be aware of from the standpoint of long-term contract negotiation. These are things that you want to look at when you get to that point of being approached by an MLTC plan. Some of you may already have signed contracts with an MLTC. You should be aware that those contracts can be, if you will, assigned to an IPA, so it doesn't lock you into that contract. The benefit from the MLTC plan is they'd like to have as many providers under one consistent contract as opposed to having to go back and individually contract with folks. Okay, so in wrapping it up here, what I would suggest you do, you look at these individual items and you look at them and you say, well, this is pretty much basic stuff. Why do I have to be concerned about that? The LTC plans are dealing with template contracts provided by the state of New York, the Department of Health, approved by CMS. Virtually every one of them that we've seen requires either modification or addendum in one or more of these areas. So the last thing you want to do is sign a standard template contract. I haven't found one yet that didn't require some modification in terms of language. Again, that's where legal counsel can be very helpful to you as well. But these are what I would consider to be the top 10 issues that need to be addressed. And then we go into the contract issues to be negotiated, talked about standard contract templates, and again, basically guidance with respect to, this is kind of a resource material when you get to contract negotiation. Okay, what should we be looking at here? One of the key items here, number 8, you shouldn't necessarily sign up with everybody that approaches you. Raul mentioned that some of these plans are going to go bust. Not everybody's going to be a survivor. When they go bust, you get screwed if they don't have the reserves to be able to pay the run out of claims. So you want to make very sure that you're dealing with an organization that's got sufficient fiscal viability and reserves to be able to meet the obligations that when you provide the service, they're ultimately going to be able to pay you. And then the contract clauses, again, this is another piece of resource material as to what you should be looking for. And again, some of these contracts do not do a very good job in many of these areas, particularly with respect to responsibilities of the long-term, they do a good job of putting responsibilities on you. They don't do a very good job of defining their own responsibilities for the plan. So that's what you want to be focused on. And so there's 15 items there, and then we go into a series of things that are negotiable based on our experience with all the plans. Again, this is your roadmap to how you would approach a negotiation for purposes of developing, if you will, a contract with either an MLTC or a PPS. I will say that the PPSs have put you on the lower end of the totem pole with respect to importance. They're focused mostly on hospital-related services in their DSRIP and their planning grant applications. But one of the proactive things that you need to do is you need to approach the PPSs and the ACOs and let them know that either you're going to approach them individually or you're going to approach them in some form of regional network in the form of an IPA or